All right, since it is now 10 o'clock, I will go ahead and convene the meeting, assuming we are all set on the live stream.
Yes, we're all set.
Thank you. Okay, again, I'm calling to order the November 14th, 2023 meeting of the Medical Record Requests and Records Fee Working Group. Any remarks from my co-chair?
Yeah, thank everyone who's able to come. I know we all have kind of busy days this time of year, so it's good to see so many folks took some time out of their day to help with this problem.
Thank you. Could I have a motion to approve the October 24th minutes
So moved.
by Mike D'Amico, second
Second.
by Representative Conley? All right, we sort of mistitled item 4. What the intention was to have a discussion about the process itself. And I think what I would like to do is have some of the third-party providers just walk us through what you folks do in the processing of medical records. And I'm not sure if we should hear from each one of you or if the patterns and practices are similar enough that one of you explaining it to us would be sufficient. So if somebody wants to hit their raise the hand button and go first. Again, I think it's instructive for all of us to just understand, particularly on the third party record side, exactly how you folks handle things. And I see Kyle's got his hand up, so we'll go to you first.
Thank you. And I see Elizabeth McElhaney also joined, and she also represents AHIOS. And I think she may have joined just after you had requested that the third-party release of information companies speak to our process. So I just wanted to let her know why I was speaking on this point. I'd like her to chime in at some point if she feels so free. She represents the association that represents all of our companies. I'm with Ciox Health, and the release of information process is, for the most part, very similar for all of our companies. We work as business associates for medical providers, whether they're hospitals, health systems, independent doctors, medical groups, whatever they might be, potentially even like nursing homes, physical therapy centers, et cetera. And our process is governed by HIPAA and also by state law with respect to the privacy rights of the patient as well as the provider, because in many states, the provider controls access to the record as well, and the record is considered their record, not the patient's record. So we follow state law and federal law regarding privacy rights and patient privacy rights. And when we receive a request for records, one of the first things we do is review the request, which typically is delivered to the provider, not to us directly, because many times people don't know that we are involved in the process because we're working as a vendor. So if you have a request for medical records and you treat it at, I'm just going to use a generic name like Memorial Hospital, you would send the request to Memorial Hospital. Memorial Hospital then has its internal procedures to get the record request to us because we're the ones who will fulfill that request. We receive the request, and the first thing we do is we validate it. We make sure that it is a request that can be fulfilled. Now that involves like reviewing the request letter, reviewing any documentation that's provided, such as a HIPAA authorization. There may be a state documentation, there may be powers of attorney documentation, there may be court orders, there may be a subpoena, there may be just a letter of agency. A lot of times attorneys will use an agent to go and retrieve the records for them. So there will be a letter of agency saying, I'm a law firm, but my agent is ABC Copy Company that has the authority to act on behalf of my law firm in order to obtain this record. So there's all kinds of documentation that can be involved in that request. So our first step is to go through and validate all of that. Make sure that this is a legitimate, valid request that complies with HIPAA as well as state law. So once we have all that documentation, we've reviewed that and we say, okay, this is a valid request. We have a patient authorization, or it falls into one of our exemptions, like maybe it's treatment, payment, and operations, right? Because I don't want this work group to be focused on one type of request. There are many types of requests, and they're not always by attorneys. They're not always like disability, workers' comp, personal injury, med mal, or even insurance defense. We get requests from auditors. We get requests from government agencies. We get requests from courts. We get requests from insurers. We get requests from MCOs who are handling Medicaid issues. So we get all kinds of requests coming in. We get continuing care requests. We get requests from patients. So we have to go through and figure out what kind of request is that. We classify it, enter it into our system. Now, one of the benefits we offer to providers that they don't have is we've got an extensive software program that tracks all of the requests and who's touching it, how many times, what they did with it, et cetera. And this is necessary for under HIPAA, we have what's called accounting of disclosures. So when a medical provider brings in one of our firms to handle this process, that's one of the things that comes along with it, is you know that you're going to have this accounting of disclosures that is going to be tracked by our companies through our technology. And so then now that we've got the request, we've validated the documents, now we have to retrieve the medical record number for that patient. So many people don't understand that in most situations, the medical record number is in different software. So we've got to go into a different program to retrieve the medical record number for that specific patient. Once we've obtained that patient's medical record number, now we can go into the actual EHR. And the EHR is where the actual medical records are located. So now we'll take that medical record number, go into the EHR, locate all of the records for that patient at that facility. Now we'll have an opportunity to review those records and make sure that we're not disclosing anything that's highly sensitive that we can't disclose without specific authorization from the patient. And that would include things like, HIV and AIDS treatments or testing, or STD testing and treatment. It could include mental health treatment and psychotherapy notes. It could include substance use and abuse testing and treatment. So there's various things that we look for within that record that require a patient to give specific consent before that can be disclosed. So we're screening the record for all of those. Not all of them are segregated. Some are littered throughout the medical record. For instance, in Connecticut, I believe it was in 2022 after the Dobbs case, Connecticut passed a reproductive health privacy statute. So we also are looking for anything that's related to reproductive health now in the state of Connecticut. And when we identify that, we need to have specific authorization from the patient. Now that could fall in like a patient's history, for instance. The patient could say like, I had a miscarriage in 2018. They could say, I had birth control treatments that I was receiving, and that's in their prescriptions. And that's all in like a history. One of the first things, if you report to the emergency room, I know there's some personal injury attorneys on the phone. If you show up in the emergency room from like a vehicle accident or something like that, one of the first things they'll ask a female is, when was your last menstrual cycle? Because they want to know if there's any chance that there could be a potential other life that they have to be aware of, a pregnancy that they have to be aware of. So all that's going to be littered throughout the medical record. It's not like these records are simply segregated. Sometimes in situations like your psychotherapy notes, they will be. But we're looking through that entire record page by page, whether it's paper or electronic, to make sure that we're not disclosing something that the patient didn't specifically authorize, that's not highly sensitive under the law. So after we get that record, we compile it and we convert it, because if it's in an electronic system like an Epic, a Cerner, an Allscripts, which most of them are at this point, that information would be useless to you all in that software, unless you have Epic, Cerner, Allscripts in your office. So we have to create a universally readable PDF. So when we create that universally readable PDF, that's technology that we had to develop on the back end to take the Epic, the Cerner, whatever, and convert it from data into something that's a universally readable page that we now have a page count and that you can receive and that you can print, that you can view in Adobe, etc. And so we do that conversion. And then if you have an electronic portal account with, say, Ciox, and I know many of our competitors, I can't speak for all of them, but I know many of them have portal accounts as well on the internet, where law firms or other entities can sign up to have electronic delivery. We will then send that record electronically to your portal account, where you then can sign in and have a secure viewing of that record. You can download the record, you can print from that actual program. But I kind of jumped ahead there because I want to back up a second. When I said we go into the EHR, I want to make it abundantly clear that with many of the EHRs, when we have like a health system, which in Connecticut, you have a lot of health systems where your hospitals are connected, but their EHRs aren't connected. So if you request a record from an entire system, like Memorial Health System, we're going to have to go into each of the hospital EHRs independently to look for that record. Because if we only go in and we look in one and we don't find the record and we send out a letter that says we didn't locate the record at this hospital, you'll probably say, well, I know that my patient treated there or my client treated there because they told me they did. So we've got to go in and look at each of the different hospitals within the system.
If I can hop in 1 second,
Yeah.
Kyle.
Yeah.
One thing I just want to kind of highlight when Kyle mentioned that we have to go into multiple different electronic medical record software is because that information doesn't flow together nicely, and because you need the original records, we do have to go back to that source system because it's the system of truth. If there were any amendments or addendums made to those documents in the legacy system, those probably don't cross over. So in order for you to have a complete and accurate record, you do have to get that from the original system. And a lot of times those legacy systems aren't maintained just because there's IT constraints within healthcare organizations, just like everywhere else.
Thank you, Elizabeth. And so another scenario would be we go in and we find a record within the Memorial Healthcare System at ABC Hospital. We can't stop the search there if there are more hospitals or providers within that system, because maybe that patient treated others. So if there are, like, say, 4 EHRs within that hospital system or that healthcare system, we've got to check all of those because you asked for any and all records. So that's what we'll do. If you send in a request and say, I only need it from ABC Hospital, then that's where the search will stop. But if you send it into the healthcare system and we've got to check all those different EHRs, there's no electronic way to do that. This is manual labor. And when we go in and we review every page of the record to validate that it is that patient and validate that it is that patient's date of birth, we use identifiers to be able to make sure that that is that patient's record. That's manual labor as well. I'd like to say that we're at a point where we can use OCR technology or NLP technology, but we're not at that point yet. Maybe that will come soon, but it's not here now. And I mean, all you have to do is look at how much we pay our labor force across the country. We've got 6,000 employees. We're not just paying them to sit on their hands. They're doing the labor. They're actually going in, they're pulling these records, they're validating, and they're making sure that the record gets properly delivered. They're uploading, they're downloading. Now, I've been questioned before when I've offered my opinion and testimony that, well, why do you have to look at every page? Why do you have to verify if a doctor enters in John Doe's record, why isn't that all John Doe's record when you open the EHR? And the reason why we have to validate that is because if there's 2 types of EHR systems that providers can have. One would be the data entry. If you've gone to your doctor and you go into the waiting room and you go in, you're sitting in the exam room and they say, what are your symptoms today? And they say, I have headaches. And they sit there and they're typing and you were watching them type. That's the data entry. That's going directly into that patient's EHR file. So we can make sure that that's probably not going to get misfiled. But many doctors still are using where they will write on paper while you're in the exam room. And then that document gets scanned in at the end of the day. So that is a full EHR provider, but their documents are scanned in and they have to be uploaded to the proper file. So it would be very similar to you sitting in your office and saying, I have, Jones or State versus the Jones and State versus James. And you scan in a document and you upload it to the wrong one, Joan or James, right? The same thing could happen in an EHR. So we're looking for those misfiles, which actually do happen. And when we catch those, we bring them to the HIM director's attention, and then they'll move those files and put them in the proper files for the right patient. So jumping back to where I talked about the delivery, where if you have the portal, that is the ideal and the fastest, most efficient, most secure means of delivery, is sending these records through the portal to the firm. You sign in, You use a verification password and a login account, and only people in your firm will be able to see that record. We can also, but we don't prefer, to burn CDs or USBs and send through the US mail. This slows down the process. It's not as secure because now you're involving the US mail. So we don't prefer that method, but that can be done in some instances. In some instances, it can. We have some facilities in the country where they do not have USB ports on their computer, or they don't have a CD burner on their computer for us to burn things. And it's because we have limited access. So when they issue a laptop or something to us, those ports are removed and we don't have the ability to actually physically burn. So if we want to create that kind of file, we typically have to ask the hospital to get involved in that process now. So a lot of people don't understand that when you ask for a CD or a USB, you're actually going to slow the process down. We can get that record to you much faster if we're using our electronic portal for delivery. Then the third method is still obviously paper. We have a system where we take all of these electronic files and we will send them to our print mail facility. And I believe we have 2, maybe 3 around the country now where we do it regionally so that we can reduce postage costs. But we'll send it to one of those print mail facilities, print out the record, and send it to you at your physical address. So you'll receive a paper copy. Now, I want to talk a little bit about that portal technology. One of the things that people typically don't understand is that if you have like a MyChart, I'm talking now not to y'all as like law firms and requesters, but as a patient. If you're a patient and you have like MyChart, you can go in there and you can see portions of your medical record, but that's not your entire record. Providers aren't required to upload everything to like a MyChart or some other program that an Epic or a Cerner offers through their EHR software. They just offer you a snapshot. It's typically got like your labs. It's typically got like surgery reports. It's got prescriptions, diagnoses, things like that. But it doesn't have progress notes. It doesn't have like you're up to date. Like if you're an inpatient and you have a nurse that's visiting you, say on every hour on the hour, those notes aren't going to be in like your MyChart. That's going to be in your EHR and we'll be able to access it. And if you need that, you can request it. A patient can be granted access to it, but it's not going to be the complete record. So a lot of providers, they offer like MyChart through their EHR software, but they don't have a way, a physical means to deliver electronically an entire record to you all. So like if you ask for any and all records and it's like 248 pages, the provider without us doesn't have a way to deliver that. That's why many providers, if they've used like a Sharecare or a Verisma or an MRO or a Ciox, they'll go to another vendor rather than do it themselves because they would have to develop that electronic technology to deliver it through the internet. And they don't have that right now. So all of us do, we can come in and just get them set up like within a day or two to have that program so that they can deliver electronically through us, through the portal, and have that safe and secure means of delivery. We've been questioned before about email. Why can't you just email me an attachment of this record? Many of the records are way too large for that. Now, granted, there are some we could do as a PDF. We could just attach it as a PDF to an email and send it off. But that is not a safe and secure means of delivery. We would much prefer to use your account and send it through the email portal to your account so that you can download it when you sign in. So in a nutshell, Elizabeth, do you have anything else that you would like to add at this point? Some of the values that we bring? I would just like to summarize by saying at the end here that my end that we actually expedite this process. I know that these bills were introduced because there's been a delay in getting the record, but our industry, we have absolutely zero incentive for delaying the delivery of any of these records. It behooves us to get you the records faster and more efficiently and more securely. And that's why we exist, is because the providers say you're able to do this much faster and efficiently than I am. And that's why you outsource things to a vendor. And so the fact that this bill came up, I wanted to be engaged because I want to find out what are the problems. I want to hear everyone on the phone tell me what are the concerns so that we can try and address those. If it's something on our end, or if it's something in communicating the request from the provider to us, because if that's a communication breakdown, then we need to address that as well. But from what I see on our turnaround times as a company itself, we have very good turnaround times. So that's why these kinds of bills really concern me. And that's why I wanted to engage. So Elizabeth, do you have anything else to add?
Yeah, I just wanted to kind of highlight two additional areas that Kyle had mentioned. One is about sensitive information, and things have when I started doing ROI back about 15 years ago, things were a lot more straightforward. It was paper. You could easily segment portions of the record, as Kyle mentioned, for psychotherapy or for 42 CFR Part 2 programs, which is federally funded drug and alcohol abuse programs. That is no longer the case. I'm just going to use Dobbs as an example. After the Dobbs decision, as we know, there was a change at the federal level regarding abortion services, and Connecticut was a state that did move to protect patient rights. When EHRs were created, they were created with a certain set of already predefined types of sensitive information. So obviously psychotherapy notes were going to be broken out, drug and alcohol abuse, mental health. Now we're trying to like kind of retroactively add in reproductive health. And as Kyle mentioned, reproductive health is an incredibly broad category, everything from oral contraceptives to miscarriage management. And I like to refer to it as inextricably intertwined. It not only is in the medication history, it's going to be in the review of systems for every office note and every H&P. It'll be in the problem list, possibly in the prior medical history, prior surgical history. So it pops up multiple places throughout the record. And so that requires skilled labor to go and look for that information to protect patient privacy. It's not something that we can, unfortunately, right now rely on OCR technology, because providers may abbreviate things differently. There may be different terms that they use. So there's not a way to ensure with technology that we catch everything. So we need that skilled labor in order to be able to protect patient privacy. And when I started, it used to be common that we would have associates that worked in our release of information that maybe didn't have a college degree. Maybe they've been working in medical records for a number of years. Now it's to the point when we start employees, we want them to have a 4-year degree, if at all possible. We want them to be accredited through organizations like AHIMA or HIMSS, so that they have an understanding of what's in the medical record, where things are found, and they also understand, as an ancillary, the importance of patient access. So I just kind of want to highlight, why we have that need for skilled labor, and why, it is a necessary step, in today's world. The other thing I wanted to highlight is I wish EHRs had the capability to like push a button and print, or output a PDF. That doesn't always happen. If healthcare providers were to rely on their EHR technology to provide the capability to push records out, that would not exist for most EHRs. So we have to go in, and it's not necessarily the straightforward process. Click print, especially like I mentioned, if it's an archive system. EHRs were designed to ingest information. So we want it to be easy for our clinicians and our doctors when they're at your bedside to be able to document, nurses to be able to, capture your vitals in real time. That was the primary consideration for EHRs. Getting information out was not. So that does pose some challenges that our companies, with our scale and our experience, we're able to bring that to the table for these healthcare providers as well. So those were just the two, kind of items I wanted to highlight, because Kyle does an excellent job, kind of summarizing what we do is a release of information industry.
May I ask a couple of questions?
Absolutely.
Sure. Actually, Jennifer had her hand up first, so I'll let her go first, and I'll go to you, Mike.
Thank you, Representative Quinn. And thanks, Kyle and Liz, for explaining the complexities. I have just a clarifying question, just so folks who are on the call may not realize. So for either or both of you, Kyle and Liz, can you give us a feel for what percentage of the market uses a third-party service like a SciOx? And I don't need exact numbers, and I'm thinking the whole continuum, right? So hospital, lab, pharmacy, clinic, FQHC, and physician. So get a feel for that, because I'm sure the smaller somebody is, the less likely they are. But I just want to be clear, everything you said is true, but it's also true for the provider who has to do it themselves. So I'm trying to get a feel for what you think are the folks that don't use a third-party service.
So I'll chime in first, Liz. Thank you, Jennifer, for the question. You're right. There still are a lot of providers who are handling this themselves. They tend to be your smaller providers, your one-off doctors, your practices that have a handful of doctors. Think like your OBGYN practices or your pediatricians. They tend to use like an office manager or someone on their staff to use this to utilize basically for release of information purposes. Now, that being said, SciOx, I know we are the provider for around, I want to say it's around 3,000 hospitals and health systems in the country. And then we service around 15,000 medical practice groups or individual providers. But you bring up a really great point. A lot of people don't realize that pharmacies use us as well. You know, we have some national contracts for pharmacies as well that do this. We also have the ability to work in nursing homes. A lot of you who work in nursing home practice, they have medical records as well. And then we have, like I mentioned earlier, physical therapy, chiropractors. I mean, medical records, there's a very broad definition under HIPAA for what a medical record is. And so you've got a lot of different providers that do this on their own. So this is not, I would say that from a hospital standpoint, Jennifer, I think the great majority of hospitals outsource this. But when you're talking about individual providers, I would say the great majority probably do this in-house by themselves. It's the minority that outsource to companies like us. Now, on the flip side of that, when you request a record from a medical practice, like an OBGYN practice, it's going to have less records and less pages than from a hospital. Hospitals have inpatients. They have what I mentioned before, like the progress and the nurse notes that are done on a more frequent basis. So you could have, a 5-day stay in a hospital that's going to be several hundred or maybe even 1,000 pages, whereas your clinician record is typically going to average around 10, 15, 20 pages, unless you're a repeat patient that's been there for years and someone requests any and all records. Then that can get quite voluminous. Liz, do you have anything to add?
Sure. Thank you. Thank you, Jennifer, for the question. So I want to say that the latest industry figures were about 75% of hospitals in healthcare systems used third-party release of information vendors. As Kyle noted and you observed, there's definitely a kind of step down once you get into the clinic systems. I would say probably about 55-60% outsource. But as you get more into like a rural environment, more underserved areas, and those single kind of mom and pop practices, there is less use of our services. And generally they do it in-house. I would like to kind of, those providers that take this in-house, they don't necessarily even always use an office manager, as Kyle mentioned. A lot of times it's whatever staff is available. So I've seen situations where an HR director is doing release of information. A lab tech may be doing it. The radiology tech may be faxing the results afterwards. And this is on top of their regular, daily duties. So they're not necessarily as familiar with HIPAA and state law as we and probably they would like to be.
All right, Jennifer, do you have anything else?
No, I appreciate that. Thank you.
Okay. All right, Mike D'Amico.
Thank you. So Kyle and Liz, first of all, thank you for that explanation. I've never had the opportunity to hear from your perspective the inner workings of the production of medical records. So that was interesting and helpful to understand. Liz, there were a couple of things that you had said that I just wanted to follow up on that I'm not 100% clear on. One, you mentioned something about legacy systems and that there may have been some IT limitations or some challenges with older systems as they morph into newer systems and how that might affect. It sounded to me like the accuracy or the completeness of the record that's produced. So if you could explain that a little bit further, it would be helpful. And the other question I had to do with at times you referred to, and Kyle referred to, highly sensitive information. There's a need at times to restrict the release of that information. Is that done by way of redaction? And if it is done when a record is produced and highly sensitive information is removed, is there an awareness in the produced record that there has been a portion that has been redacted or removed?
Okay, thank you very much. So for your first question with regard to legacy systems, legacy systems are kind of the precursor EHRs. A lot of times healthcare organizations grow by acquiring other systems or by other hospitals or clinic groups, and oftentimes they'll have their own EHR. So when they acquire that organization and bring them in-house, in-house and under the larger umbrella, they have to decide what to do with that previous EHR system. Most of the time they want to get everybody on the same platform. So that, legacy or existing smaller EHR is going to be kind of decommissioned. There's not a really elegant way all the time to bring those records into the current system, especially when you start talking about scan documents or other images. So most providers, because of the cost, they'll opt to just kind of use that in a read-only state. The problem with that is over time you have staff attrition, so you don't have as many staff remaining who are experts on this system. You're not also updating the system as, some vulnerabilities are found or as there's increased functionality because you're just in a read-only mode. So that does make information challenging to get between those systems. I'll let Kyle chime in afterwards, but that is, and it's more common than you would think. I've had healthcare systems that we've worked for that have had 13, 14 legacy systems. And they each have their own quirks. They each have their own logins because they don't sync to a single sign-on. Sometimes you have to run outdated JavaScripts, which then conflict with other systems. And so those kind of, requirements and the lack of IT support does make it more difficult to generate an output. With regard to highly sensitive information, so federally, the only type of highly sensitive information that's recognized is federally funded drug and alcohol abuse programs and psychotherapy notes. The rest of the kind of broader categories of sensitive health information is devolved to the states. So Connecticut would have its own laws regarding what it considered sensitive. But by and large, that's going to be your reproductive health information, STIs, HIV/AIDS, in some cases, other communicable diseases, like tuberculosis. Kyle, what am I missing here?
No, I think that's pretty much it. I think to his point of redaction, most of the time, our companies are not charged with redaction because of the way this information can be littered throughout the record. So what you will receive from us if we identify those records is a request to have an authorization signed to release any and all information, including highly sensitive information. That way, the patient will be forced to sign an authorization, checking that box and acknowledging that that can be released. When we receive that, then we will release the entire record, including all of the highly sensitive information. That gives that patient that opportunity to say, oh yeah, you know what, I do have a treatment for HIV that I didn't mention to my attorney. And you know what, I really don't care that he knows about that. So I'm going to go ahead and say, disclose the records. If we are not able to obtain an authorization with all the highly sensitive information checked off for release, then we will take it to the HIM director and we will go through a redaction process, typically as a team. Because whenever you get into redaction, you're going to talk about more clinical information. And so our people are, here's a term familiar with attorneys. Our people are typically issue spotters, right? So we identify, okay, we've identified some HIV information. We are not necessarily going to be able to capture all of that. So we're going to work with the HIM team and clinicians whenever redaction is involved. Now, if that record is redacted and then disclosed, your next question was, is that tracked in the system that not the entire record was disclosed? We don't track per se in our system that we sent a redacted record or that we sent certain pages, but not others. We don't track that we sent I'm trying to figure out how to say this. We don't say which pages may not have been disclosed. We just know a page count, if that makes sense. So to go back and replicate and say, this is exactly what we produced the first time, we aren't necessarily going to be able to do that from like a chart. Now, that being said, we do have an electronic image of the record. So we could do a side-by-side comparison. Does that make sense?
It does, and thank you for that. I was more interested in whether or not the person receiving it who made the request would have an awareness that certain information was redacted, or would it simply appear to them to be a record and they wouldn't know one way or the other?
They would not know. No, because we don't alert to the type of highly sensitive information that we identify or that we've redacted any of it, because that calls attention to the fact that it does exist. And that in and of itself has to be protected, that information exists. So when you get a correspondence letter from us saying we need you to get, that's where we get some pushback from law firms that request records saying, I don't understand. You're asking me for an authorization and I sent you one. It's because we can't be real specific about what we identified. Because we can't say we found HIV testing in the record, so therefore we need you to get an authorization for that. We just say we found highly sensitive information. Would you please get an authorization signed allowing the disclosure of highly sensitive information? That way you're not aware as a requester what we located until the patient authorizes its release.
Thank you.
And what I was referring to there, and I think I just figured out a better way to say this. We have the accounting of disclosures that I mentioned. In the accounting of disclosures, you would have no idea of knowing if there was any redaction or what pages were produced or anything like that. That's where that's like think of it as like a spreadsheet, right? And that would just say, this record was sent to this person, this is how many pages, et cetera. But then if we actually pull the record ourselves from our system, the image that we have, that's when we could do the side-by-side comparison. So we do know when there's been redaction, it's just not in that like accounting of disclosure. We would have to do a deep dive into the information.
Did you have anything else, Mike?
I did not, and I'm interested with other ideas that folks have. It's very interesting so far. Thank you.
You're welcome. Rick Silver, I know you had your hand up. Is it now down, or did you have a question or comment?
No, I have a comment. If I can make a comment on the
Sure.
delivery just made. I didn't attend the last meeting, unfortunately. So let me just give you a little bit of my background. I'm presently co-chair of the Med Mal Committee of the Connecticut Trial Lawyers, which I've done for about 30 years. I'm a past president of the Connecticut Trial Lawyers. I'm on the board, and I'm the senior partner of Silver Gulf and Titel. And essentially, the majority of my practice is medical malpractice. So here's what my concerns are, what we just heard. The first concern is, and I'm not disputing it, is that the portal system does not allow the patient to get any meaningful information. In other words, not only is it not meaningful, sometimes it's very deceptive. I've had occurrences where the portal system has not revealed important information. And our big problem is, while there's an indication that these intermediaries help in getting the records faster, that's certainly not been our experience. Our experience is that they cause delay, that when you call once, twice, 3, 4 times, there's either no answer or not an appropriate response. So my concern, one of my major concerns is delay. And so I essentially dispute what I just heard nationally. It's not true of what happens in Connecticut. Now I'm talking about hospital records. I'm not talking about physicians' records. So that's what my concern is. And I'll tell you why delay is so important. Oftentimes a client will come to us, a patient, very close to the statute of limitation. In Connecticut, we cannot bring a claim unless we have a physician or a PA or a medical person give us good faith, a good faith certificate. Can't do that unless we have all the records. So that's one of the major problems we have if we have a client who comes in, and it happens very often, very late in the proceedings. And and one of the interesting things is there are some times when a client comes to us and says, you know, I'm having an operation in 2 weeks. I need past medical records to give to my new physician or new surgeon. My experience in that case is when the patient goes directly to the hospital, and sits and waits all day, they get a disc of their complete medical record. So in that unusual case, they do get it, because in that case, there hasn't been an interference by the third party to delay them getting the records. So what I'm essentially saying, I'm concerned about a statement that there's helpful by these paid associations that they get the records more quickly. And so our experience is, you know, the federal system allows us to get a disc for $6.50. And my experience is that even though the patient has that right, the interference by these providers delays getting it and objects to the attorney who represents the patient getting the records directly. So it forces the patient to get the records directly and then transfer them to the attorney. So what I'm essentially doing is I'm concerned about what I heard is how much time and effort, and that has not been my experience. My experience is for hospital records that we do get in the final analysis, we do get a disc that contains everything. I've never had an experience before when the disc has been censored. Well, I had one experience when a key document was removed and we didn't get it. We had to go to court to get it, but that's been very rare. Essentially, once we get a disc, it contains everything in the medical record. Thanks a lot. Appreciate your taking my.
All right. Thank you. I know Kathleen had her hand up first, but Kyle, do you have a direct response to Rick's questions?
I just did want to say that when a patient goes to a hospital and goes to the HIM department and requests that their record be produced to them at that point in time, our people are embedded in the hospitals for the most part. So that's still us producing the record. You're not avoiding us by going to the HIM department personally. That's typically our people. I mean, we have dual badges, typically dual security badges. One will have SIOX, the other one will have the provider's name on it so that we can get in through their security gates and doors so that we have access to the medical records.
Okay. Thank you. Kathleen.
Thank you.
Thank you, Representative Quinn, and good morning, everyone. And thanks to Kyle and Liz for the explanation, which I also had not heard before, and it's pretty interesting. It sounds like both of you, and maybe this is not true, have experience with not just Connecticut systems, but systems around the country. Is that fair? Okay. So I'm wondering if, to keep this sort of Connecticut specific, my question is, it sounds like a lot of the legwork, the manpower or person power that it takes to produce a record becomes necessary when the authorizations do not include a request for the highly sensitive information category. And if there is a legacy system that might slow down the production of records because you're trying to blend two EMR systems. So it's like a hypothetical. If I send you a request, and our requests always include requests for sensitive information, because as the plaintiff's lawyers, we want to know that stuff. So if I send a request to a Yale health system, which is on Epic, and it includes sensitive, highly sensitive information. So you eliminate that part of the process. And if it is a request for a relatively current hospitalization, so you're on a current version of Epic, which can be converted, I think, fairly easy to a PDF. How does the process change from what you described, Kyle, which is very time intensive, to a more straightforward process? Is it a lot easier?
I wouldn't say it's a lot easier because we still do go through and review every page of the record that we're converting. And the reason why is because we don't want to be in a situation where we've disclosed a record that is not potentially that patient and that authorization, and then we have an unauthorized disclosure on our hands, because that will be reported to OCR, the Office for Civil Rights at the Health and Human Services Department, and then the provider that we're working for won't be happy with us for disclosing a record that wasn't authorized. So I think what you're getting at is you're saying, look, if we get to the point where there are no misfiles, and I have an authorization that allows all highly sensitive information, can't you just go in and highlight a file and say, John Doe's visit from January 3rd through January 8th, copy and paste, done? I mean, I think that's what you're trying to get to, is how can I make this easier for your companies to do this so you don't have all the time and labor and thereby reduce the cost? And I appreciate that. We've tried to streamline the process over time so that we don't have one person doing the record. We have multiple people touching it that are trained in various tasks. So it's kind of like a production line, if you will. So
Well,
that's why.
Sorry, go ahead.
No, the point really to my answer of your question is that we still have to go in and make sure we review every page, because we don't want those unauthorized disclosures. But you are right about the highly sensitive information. If you hand us an authorization that those boxes are checked, we're not going to be screening for that. But we will be screening to make sure that we've got all the record and make sure that it's appropriate to disclose.
So if I get a record from Yale that is 8,000 pages long, are you telling me that someone from SIOX actually has to sit and personally review every single page to make sure that it's my client and not some random patient that got mixed up in the process?
Unfortunately, that is what we require. Yes.
I mean, then this is not a criticism of you, but that makes no sense to me that in the age of electronic medical records, that still happens, it does.
It does. And I've taken legislators on tours of our facilities to see them doing it before, when they wanted to be educated on the process. And we have people, I mean, this is heavy labor. And that's what people tend to forget. They think that this is with high tech and the Cures Act, that everything is as easy as just push a button. We don't have interoperability yet between providers. It was very well publicized how the Connecticut Health Information Exchange was not successful and how it couldn't even continue to operate, I believe. I mean, the medical profession is trying to figure out how we can get these records to flow from one source to another in an efficient manner and in a secure manner, because everyone is concerned about data privacy right now. There's no shortage of articles written on a daily basis coming from state government and from federal government that data privacy is on the top of people's minds right now. So to just say, well, just disclose the record, there can't be anything in there. We can't take that risk, because we get complaints every day from people who say, you disclosed my record and you shouldn't have, or you disclosed this page of my record that had this information. Now, we try to minimize that. When I say it occurs every day, what I'm saying is when you're a company of our size and you're in 50 states, you're going to have those occasionally. But in proportionate scale, that's minimal, right? So we're trying to minimize that. We're trying to get this right and only disclose what patients authorize.
Now, are you able to just give us, and then I'll be quiet because I know that other people have their hands up, but are you able to give us some idea about how many times in Connecticut a request has been sent and there's been some other patient's record contained in there? Because if that's happening, that's something that the Department of Public Health or somebody else should look at beyond this committee to make sure that the hospitals have some, checks in place.
Keep in mind, that's what we're supposed to be preventing. Right? So you don't know when it would have occurred because we prevented it.
Well, the hospital should be preventing that. And then you're like the check on the hospital, it sounds like.
No, they delegate all of the release of information process to us. When they get a request for records, they hand it to us and they say, we're done. We brought you guys in as the vendor. You're responsible now.
But what I'm saying is you wouldn't have that problem if the hospitals didn't mix up the records in the first place. Right?
Potentially, yeah, because we do not upload records to different files. Correct. Okay. Yeah. I can't speak for all the Ahios companies, but I know that we are not responsible for uploading records to patient files.
Okay.
That's not one of the things we do.
Thank you, Representative Quinn. I'm going to be quiet now.
You're welcome. Jennifer again.
Thank you, Representative Quinn. I just want to clarify, it is a known problem with EHR, EMR systems that there is cross-contamination of records. It is not the hospital's fault, but I appreciate you bringing that up. I think that's past the purview of this. I think that's a false issue for what we're discussing. So you can read the literature that it's actually the way the EMRs are built, and it is ubiquitous throughout the healthcare continuum. It is not just hospitals. And although Kyle's company has nothing to do with it, it happens all the time. It is an artifact of the records trying to be interoperable so that we get the true record of all the records in one place. So that's something you can read about. I'd be happy to find some articles, but I think that's beyond this workforce's theory. A couple of things I agree completely with Kyle that this is incredibly labor intensive. However much you think it is, it's more than that. I disagree with Kyle that they are doing all of it. There's a lot of folks that do this themselves still, or do a lot of the upfront work, and there's a queue. So when you're saying, well, how come I can't get the record in 2 weeks or 3 weeks or whatever it is, why are they taking the 30 days? There is a staff. Part of it is before Kyle's work. Some of it was having nothing to do with Kyle's work. They're dealing with subpoenas. They're dealing with thousands of requests in a queue. They attempt to expedite things for care that are for urgent care mostly, or for other care issues. And it is true, and maybe that's something we need to look at, that does put legal things behind care, because if you've only got so much time, that's what's going to get prioritized. And it's a serious queue. It isn't that there's 5 people there that can deal with your problem today. So when a patient goes there and begs them because they're going to have an MRI to find a tumor, they go to the expedited process. They can't do that with everyone, obviously. You can't expedite everyone at the same time. Additionally, there's something that hasn't come up, and it's specifically important to workers' compensation records, which we don't seem to be focusing on today, but I think maybe we should. There's something called the minimum necessary standard in HIPAA. So even if you had the perfect sensitive information authorization, and if you need an authorization, it always has to be a HIPAA compliant authorization. It can't be a different one. So a HIPAA compliant authorization that checks all the boxes for federal laws and state laws with sensitive information, if it is specific to my workers' compensation injury, you still have to apply the minimum necessary standard, because Connecticut law, intersecting with HIPAA indicates that the information that can be disclosed for workers' comp has to be workers' comp injury related. That is a rat's nest of information. So there's another, if we're going to expedite this to have the perfect authorization for workers' comp, there's going to be a decision to be made at a policy level as to whether or not we're going to change the law that allows a workers' compensation injured claimant to have to turn over everything, or are they still able to keep that part of information that isn't related to their comp injury? Because that's a serious question that if we're going to have any meaningful input to help the legislature figure this out, is going to come up. Can a injured worker in Connecticut under our Workers' Compensation Act continue to hold back information that is not related to the injury, and who decides that? Because that's what's going to stop the flow for workers' compensation records.
Thank you. Rachel.
Hey, good morning. I also was not able to attend the first meeting. My name is Rachel Pattison. I am an attorney at the Hartford. And just a quick question for Kyle and Elizabeth. If a claimant requests that sensitive information not be disclosed, so they don't check that box, does that redaction process then add time on to the request?
Absolutely.
And who does that redaction again?
I'm sorry?
And who again does that redaction?
The redaction is not done solely by our company. I can't speak for the HEOS entities, but the reason why SIOX does not assume responsibility for the entire redaction is because there's a lot of clinical work involved. You've got to understand the medical terms, the certain names of the drugs, what they're used for, et cetera. And like I said, we're issue spotters. So we'll work with the HIM team, who may bring in a nurse practitioner or a PA to assist us in actually redacting the record, which we have delivered those from time to time. But again, our preference is to send out a request that the attorney or whoever the requester is gets an authorization allowing the release of the highly sensitive information. That way the patient at least knows and consents to it.
Across the HEOS companies, there are some that handle redaction themselves, but they do have clinical staff members employed for that purpose. So they would employ nurses or sometimes PAs to be able to facilitate identifying that clinical information. But most of the companies, I would say, probably, follow the same process that Kyle described, that we would produce those redacted records in conjunction with the HIM department.
Do you have any idea how much additional time that might add the redaction process?
No, it's really going to depend on the size of the record and how much information.
Okay.
Yeah.
Okay. Thank you.
Thank you. Representative Conley.
Thank you, Representative Quinn. I had a couple follows based on the presentation so far, and I appreciate the knowledge. But one of the issues that I see often is records requested through the office, through the doctor's office or hospital office, the records request fax or email. And then when conversation with the vendor comes, the request never got to the vendor. And then the vendor wants the request to be, of course, they don't have it, so it's not in the queue. So instead of being, it's 30 days have passed, the requester doesn't have the records, they've patiently waited. Again, they have their confirmation fax, email, letter if they chose to snail mail it. So they're, in their mind, they're behind the gate 30 days, and then the vendor then puts you at the end of the queue. Is there a way that we can deal, or is there a way that the vendors can think of how to deal with this situation? Because that seems to be, I saw a lot of heads nod, that seems to be a very common problem in the request for records, is that it didn't get to SIOX, MRO, it just didn't get there in the beginning.
Thank you for that question, and I appreciate you acknowledging the fact that there can be a delay between when the provider gets it and when we get it. I can say that I don't know of a perfect solution to that right now, unfortunately, but I can tell you that a number of our companies I know, including SIOX, are working on a way for providers to be able to request the record directly through us and upload your authorizations and whatnot through, say, your SIOX portal account, so that you don't have to go through sending it to the provider who then has to send it to us. So it's cutting out that middleman in the delivery process, and you'd be able to just upload it to us. Now, there there are obviously certain requests we can't do that for, like subpoenas, for instance. If you're sending a subpoena, it's got to be properly served. And we're not an agent for service for the provider. But if we're talking about a simple request like a patient authorization, that can be delivered to us. And if we have access to that record and the provider has signed a business associate agreement with us, then we would be able to retrieve that record. Where we'd run into the problem is, like, let's say hypothetically, you need Memorial Hospital's record and we don't service Memorial Hospital, but you're familiar with our account. Most of your records come through us. So you upload it to us. We would then check our system and say, I'm sorry, we don't service Memorial Hospital. So that's going to be a delay. But that, again, I think that's going to be kind of unavoidable, unless, of course, you had a list of these are all the hospitals or providers that SciOx services, and you could cross-reference that and then not upload those requests to us because you knew on the front end, this isn't one they'll be able to handle. Does that help?
A little bit. And my idea for resolution, if folks want to just think about it, is that when the hospitals, the entities post online how to request their records, that they would also post online how to get them through the third-party vendor. I think that would solve a lot of problems, especially because some of the third-party vendors we can direct ask. Some of it's, request through MyChart or request through this portal website. And if that information is not presented to the party asking for the record, it's causing unnecessarily delay.
Well, to your point, and I mentioned this in I believe our first call, Utah last year, I worked specifically with with a legislator out there and with the trial attorneys in the state of Utah, and because they were interested in this penalty provision as well that you all mentioned in a couple of your bills this year. And one of the things they added in their bill was that the Department of Health maintain a website page that lists the medical provider and who their release of information vendor is. So that way, and they have an obligation then to update that. So that way, then the attorneys can go out and look at a provider on the website and say, who is their release of information vendor? And so in that respect, you would be able then to make a request directly to us. Again, I temper that with, if it's a subpoena, it's got to be properly served, and we are not agents for service. But for the typical request for records, I think that would be a viable method.
My second question is, and I'm bringing it back to workers' comp a little bit. So workers' comp records are often needed for insurance authorization. And I hear from a lot of the providers that it would probably be impossible for the third-party vendors to know who is needed for insurance authorization if the request is coming from an attorney's office, either the attorney representing the insurance company or the attorney representing the person. And when I hear saying like the statement of some things are prioritized, I feel like if it's coming from, my office, Rep. Quinn's office, or someone else's office, you're processing that as an attorney request.
I can't say definitively that we are or aren't, but I will say that I can understand why you would have a need for a prioritization of those authorized requests for authorizing medical services in a workers' comp scenario, so that it would, in theory, fall outside of the typical attorney request that may not be as urgent. But then again, Mr. Silver mentioned that he's oftentimes up against the statute of limitations and needs the record to be prioritized. So I understand there are times when attorney requests, like the workers' comp scenario you mentioned and the one Mr. Silver mentioned about statute of limitations, where an attorney request should be prioritized. I'm very sympathetic to what Jennifer mentioned earlier. When you prioritize everything, you prioritize nothing, because everything can't be a priority. And so prioritizing everything means that nobody's ahead of anybody else now.
Yeah.
So
and
we
with
have
all
to
due
figure
respect,
out.
Kyle, if we're prioritizing authorization, if we're
Right.
prioritizing records for authorization or
Right.
record requests for second opinions, we have to do that all the way through. We can't just leave the attorneys out and act as if the attorneys aren't doing the same thing.
I
So
understand.
If you
And
have an internal prioritizing, it can't just stop outside of attorney request. So I'd think, and you might not be able to think on your feet for that. I'd like to hear of a solution, because the attorneys who represent the insurance companies and workers' comp are attorneys. And
Right.
they're the same as Aetna. They're the same as Blue Cross Blue Shield. Some of them represent Blue Cross Blue Shield, but it's coming through as an attorney request. So that's I would say, a problem with the system that we need to find a solution.
Understand. Thank you.
I also had some concern. I'd like to have an opportunity to maybe make a correction on the record about the redaction. So if two people ask for the same record, and I'm thinking an attorney representing the injured worker on a workers' comp case and the attorney representing the insurance company, could those two people get a different record with the internal redaction?
With the redaction, I'm going to preface this with there's always room for human error, right? So I can't say definitively, okay, those records should match no matter what, because human error does exist. But if the insurer receives the same authorization as the attorney had, then they should get the same redacted record if they have the matching authorization that allows for the disclosure or not disclosure of highly sensitive information. So in theory, those should be identical records if the requests were with the same documentation. Does that make sense? And does that answer the question?
I hope that clarified it. I had some very big concerns when folks talking about different people going through the request and different people deciding, trained to a higher or lower level, what is considered sensitive or what isn't, in the thought that if the insurance company is receiving different information record than the second requester, usually the attorney, we have a big situation. That isn't for this group, but I'd like to give you the opportunity to clarify that.
Yeah, I don't think it's a situation where you'd be receiving different records. And with respect to the different people and responsibilities that I mentioned, that was where we train people to, like, you'll have one person who's receiving the request package and we'll review and validate that and enter it into our system. Then we have another person who's responsible for indexing that as what type of request it is. So they'll be responsible for looking at it and saying, okay, this is an attorney personal injury request. This is a disability application request. This is an Aetna pre-authorization request, whatever it might be, right? So you got the person bringing in the documents, then you got someone indexing it. Then you've got somebody retrieving the medical record number and passing that along to somebody. Because when you're in these hospitals, you're talking like thousands or tens of thousands of requests in a day. I mean, Jennifer mentioned that too. She's familiar with these large amounts of requests that come in, and it's more efficient to do it that way than it is to have one person pick up John Doe's request and follow it through the whole life cycle.
Now, is there a way in the system, if let's say, just to use my attorney Quinn as an example, or Rep Quinn as an example, if I requested the record and I represent the insurance company and he requested, Dr. Smith's visit from last week, is there a way where that second request can be noted that is it noted that someone else requested it and you can just pull from the PDF that was already created? Does that exist in the system?
So we would be able to identify that there was an additional request made for that record because we do track the requests. As far as the process for can we just pull that record, it's not in our system now. I can't speak for the Ahios companies, but in our system, that record is not attached to that request history and trail, if that makes sense. It's stored separately. So what we have is a number that associates with that and the request documents themselves. So you've got a corresponding number. So then we would go onto our servers to pull that document. So is it possible? I guess in theory, but it's not something that our people on the front lines would do. That would be an IT function for us to go and pull it from the server. Does that make sense?
Sort of, but I'm thinking more in the workers' comp world. You've got at least two parties requesting the same visit every time. So is there a way to not double the work that's happening? So
yeah, I would think.
How about the MRI report? So
how about a statute that requires that when a party requests a record, a duplicate be sent at the same time? Would that solve it?
Well, I don't think that you being the provider, would you know that Attorney Quinn was on the other side of Representative Quinn was on the other side of the case?
Well, I think it depends at what point you are in the litigation, right?
No, for workers' comp, it's always the insurance company and the person are always entitled to always need the records to approve the next step in treatment.
Well, no, I understand that. I meant as far as identifying that Representative Quinn was the attorney for the insurer. That's what I'm talking about. Like, do you request the record before you know who the insurer is? Because and maybe this is where I need to be educated more on the workers' comp process and flow on your end. And I'm more than happy to hear about that during these calls. Because if there's a more efficient way, I do know that some states require that a duplicate copy be sent simultaneously. I don't believe Connecticut's one of them. I'm not familiar with that specific provision.
Yeah, and before we go down that rabbit hole, maybe that's something we'll touch base for another meeting, about the process. But I would say there is always an insurance company, and there is always either an unrepresented claimant or a represented claimant. So you always have at least two parties, sometimes multiple, sometimes 7 or 8 parties on the same case. But they are all asking for the same record. And I think that might be something that we could help to streamline.
Yeah, definitely. I mean, if we can do that and knock out all those requests at one time, and I mean, that's basically like sharing your discovery, right?
Yeah, because a lot of emails that you see throughout the day is, do you have the MRI report? Do you have the last visit with the treater? Do you have this? To a group who are just looking for the documents.
No, that's a great suggestion. I mean, would you be, well, can you tell me, first of all, in Connecticut, is that the law that the record has to be shared with all parties at the same time when it's requested? Because maybe that could be one thing we consider.
So the law is currently that the injured worker is entitled to a copy of all their bills, all their records. And when bills are sent to insurance company, the record has to be attached to the bill. Is that correct, Rep. Quinn? Did I miss anything?
Yeah, but I don't think that the law does exactly what Kyle is suggesting that other states do, where there's the automatic duality of disclosure. And I don't think that that's the case here.
Yeah, I've never seen it.
And then I guess the next question is, should it be the case here?
Yeah, I think that's a good question for all of us.
Yeah, and those were the other thing I want to deal with is the misfiling. I guess I see it a lot. So just to be clear, I think it is a problem. And a big stack of ER hospital records. There are a lot of there's still an issue in Connecticut. So if we've used all this labor and we still have the problem, now I think most at the law firms, we will just shred the other person's confidential medical record. I think the bigger issue is if it goes to a person directly and you're sharing someone else's confidential medical information. We have common names. We have you have dates of, we see people with very similar names and very similar dates of birth in one office alone. So I'm sure the hospitals have a bigger problem with dealing with multiple patients. If you have, a John H. Smith and the 2 different people have dates of birth, 1 digit off, you're going to have issues as much as you try, especially in an ER hospitalization where you're seeing multiple specialties. So if you have issues where you're seeing the nurse specialty, where you're at the ER, where at the ICU, where you're at radiology, you have all these opportunities for people are putting in name and date of birth. So I know it's not the purview of this committee, but maybe something more with scanning the wrist bracelets in the hospitals, if that's something folks can think of, might help that problem, because it is, I would say, still very common. That's all my questions.
All right, thank you. Mike D'Amico. And you're on mute.
There we go. I continue to be impressed by the differing perspectives. As a trial lawyer who represents only folks that have been injured, I just wanted to set forth, as we try to coalesce all these perspectives into a workable bill, really 5 concerns that we have. One is making sure that the lawyer can request the records and not just the patient. It's been the bane of our existence in terms of the current federal law. So that's the first issue. The second issue is to make sure we can get the records at a reasonable cost. The current statute, as we know, is antiquated, as we discussed the first time around. What that reasonable cost is something that is certainly important, particularly in those situations where there is a treater who is treating a patient over an extended period of time, and there are updates that need to be requested. So there are multiple requests that we often have to send out to the same providers over a period of years. And so there's the reasonable cost in the initial request, if you will. I'm in a conference, a reasonable cost at the initial request, and then there's these recurring requests that have to be made. So those are two issues, and they're ones that we've talked about in our general tort committee for the trial lawyers, of which I'm a co-chair. The other is timely. We need to make sure that they're timely, and as Rick Silver mentioned, there are circumstances, as well as Representative Conley mentioned, where we need the records more quickly than a 30-day turnaround. And if there was a provision that, even if that were to be at added cost, if there were a provision that was written in that would allow us to get the records more quickly, that certainly would be helpful. The third thing that I wanted to mention is complete and legible. One of the difficulties that we have is they're oftentimes not legible and oftentimes not complete. And so we do need to make sure that if we're going to make informed and intelligent decisions based on records received, that they're complete and they're legible. And the last thing is how do we have some type of mechanism in place that would allow enforcement for whatever the requirements of the statute are, so that if something is not timely or it is not complete and legible, that there's some consequence to that, so that it discourages those types of mistakes or problems. So those are really the 5 things that as trial lawyers we have significant concerns about. And I did want to just quickly comment on something that Rick Silver had said about a portal, and I'm wondering if Kyle, you were talking about the same type of a portal that Rick was. So I just want to. My sense was that maybe we weren't, but I just wanted to clarify that. I do know, as you mentioned, Kyle, that if there was something like a MyChart or something like that, which can be referred to oftentimes as a portal, those records, as we know, are not complete. I thought you were referring to, Kyle, and you correct me if I'm wrong, a different type of portal, and that was a portal that was provided by your company that allowed a lawyer, assuming we had an account, to access the records directly through that portal. And I would expect if that were the means of transmission and access, it would be complete, accurate, and legible. So I'm just looking for clarification on that, so that we're not talking about 2 different things. And thank you, Representative Quinn.
Thank you for that question, Michael. And yes, you are on point with the distinction of the 2 portals. Your explanation was on point. We have like the MyChart portals and whatnot that are provided by the EHR that are snapshots of the patient's care. And then you have the portals that are operated by companies like Ciox, MRO, Verisma, and those deliver the entire record. We have the ability to send, well, I don't want to group a HEOS in. I know Ciox, we have the ability to send like your itemized billing statements and all of the records that would typically be deemed your paper records. Now, we don't have currently the ability to take an actual like MRI and send that through our portal. So that we would have to burn to a CD and send that to you, or a USB or something of that nature. But yes, our portal is able, the Ciox portal is able of delivering the entire record minus like the images.
So on the HEOS end, really quick, most companies do have what Kyle mentioned, a company portal for the delivery of full medical records. There are some companies I know within the organization that are working on ways to electronically provide imaging, but that is kind of a work in progress right now.
Yeah, the imaging is and thank you for bringing that up, because it has been a particular challenge for us. Even sometimes when we get imaging on a CD, it requires us to download a program in order to make it readable and functional. I don't know that we're going to solve that in this working group, but obviously receipt of imaging is critical and important as well.
Right, Jennifer Cox.
Thank you, Representative Quinn. A couple things just for clarification. I think that if we could all put our thinking caps on to try to solve the problem, which will be the legal problem in workers' comp, how do we ensure that if there's automated send of a record at some point, that we are staying within the work-related injury? So you have an MRI, everyone thinks it's going to be something, and it shows something else outside of the work-related injury. What's the stop on that? Because you're coming back to the question of whether Connecticut will require the records to go, whether or not there's been an assessment of whether it's still within the work-related injury. So that's going to be at the end of the day, that's going to be our hurdle. And I'm sure it's solvable. I can't think of the answer right now, but that's there no matter how fast you do it. So right now, as I understand Workers' Compensation Act, the reports, right, go automatically to everybody. The reports that somebody has the quiet reflection to decide what the report's going to say, but records don't, right? Two different things because of this problem. Like, is it a work-related document right now, right? Additionally, sometimes you're getting different records because the computers in the systems are updating second by second. They get new information. It could be 30 or 45 days later, so it looks like the same thing to you, but it's actually it's a living document. There isn't like the exact same thing. It just doesn't live in that world, and it's the nature of how the federal government required EMRs to be built. And I'm just going to repeat, the fact that there are interspersed records is a function of the way the federal government required EMRs to be built. And Connecticut actually does a very good job, which may or may not make you feel better. I don't know. But that is actually something we do very well compared to a lot of places. So it is a constant battle that providers are aware of and work on, but it isn't the providers need to understand it's happening. They know it's happening. They have entire crews to work on that. So I appreciate the interest in that, but if we could focus on I think we would have success here. I think we might even get to an agreement here. If we could focus on how to do the workers' comp record in an automated fashion, as Representative Conley suggested, where we can solve that problem about not requiring an injured person to give up their rights of privacy for things that may all of a sudden turn out not to be within the scope of their work-related injury.
Thank you. I've got a couple of questions myself, but before I do, does anyone else have any comments or questions, particularly the people who haven't asked anything as of yet? Susan. You're on mute. I so enjoy getting to say that.
Hi, so I'm Sue Schaffman. I'm the executive director at the Connecticut Orthopedic Society, and the orthopedic surgeons of Connecticut did submit testimony on this bill back in the 2023 legislative session in opposition to a lot of the components of this. And I hear what everyone has been saying on this call and the previous call. Appreciate the information about third-party vendors. Very, very helpful. I just want to say a couple of things. So the orthopedic community obviously deals with injured workers, tens of thousands of them. And as far as we're concerned, our entity hasn't been aware of or been notified by the Workers' Comp Commission that this issue of medical records exists for the patients that they care for. So we were trying to figure out how to obtain that information or data that shows that it's a significant issue at this point in time in Connecticut for the workers' comp patient and the physicians, completing the medical record requests. Furthermore, I would just also want to say is, again, the vendor information, really interesting. But I think it was Liz that indicated that about 55 to 60% nationally of physicians are utilizing the services of a third party. And it's a minority of them are, outsourcing this. So I think any continued communication, that I would just request that this committee be cognizant of the fact that there's still, say 40% in Connecticut of orthopedic surgeons or physicians in general, right, that are still doing this manually. So that should be considered when its cost is considered, timeliness of receipts, the medical records is considered. So I really appreciate time and a very interesting discussion. So thank you.
Thank you. Susan, do you have, understanding that we were quoted a national statistic, do you have a Connecticut specific statistic on how many of your members are handling their own records versus using third-party vendors?
I mean, I don't. That's what I was kind of hoping to get from the experts here, Kyle and Liz, if they had an idea within Connecticut, the entities they serve that are in private practice, and not, larger groups like Orthopedic Associates of Hartford or some of the other larger groups throughout the state. But I do know that representatives on our board, there are several, right, that are independent practice in New Haven and Torrington, serving the rural area. And they have expressed that concern that they don't know of any specific issue right now, because we haven't been informed from the workers' comp that this is a concern. And so, we'd love to have that data or the information of the concern of not receiving timely information within the 30 days and the cost of the records, which I believe is at 65 cents per page at this time. What is that concern as it relates to really just the orthopedic community? I mean, I can't really speak to all the physicians. I know Mike Johnson is here representing the State Medical Society. He might have some more information, but I'm just trying to focus on our, on the orthopedic community in Connecticut.
Okay. All right. Thank you. Marie.
Yeah. I just I've been listening for a long time. As I said last time we met, I'm not here to help formulate legislation. I'm here to sort of give input from the workers' compensation perspective. And after listening now for quite some time, I thought maybe this might be a good time for me to sort of speak up on a few things. First, I actually was a little surprised by what Susan just said, because why the Workers' Compensation Commission doesn't keep statistics, that would be impossible for us to do, as to timeliness of receipt. This has been the subject of numerous conversations, that medical records are not received in a timely fashion. I don't know, I know Jennifer, you represent CHA, right? But most of the people who are attorneys on this are claimants attorneys. I don't see any respondents attorneys. You must realize that not only does the Workers' Compensation Commission have to protect the rights, the privacy rights, the due process rights of claimants, we also have an obligation to protect the due process rights of respondents as well. Sometimes respondents need records other than records that are specific to, date of loss is March 1st, 2023. They may need records that predate March 1st of 2023, because perhaps the week before the person was in a car accident. So trying to walk that line of what is work related to that date of injury and what is relevant to the case before the administrative law judge may require respondents to get records in addition to ones that are only generated date of injury forward. So as you're talking about streamlining the process, which clearly needs to be done, you need to keep due process rights of everybody in the mix. The question that I had for Kyle early on was, because it does seem like a lot of the complaints we get here at the chairman's office have to do with third-party vendors. And I think somebody, I forget who it was, mentioned, oh, you send a request out and 30 days go by and you check on it and you send the request out, you call up and they say they never got it. That's a common thing. I understand, Kyle, it certainly sounds much more complex than even I was anticipating the process to be. But can you explain to us a little bit about, and I know I'm speaking in generalities, but time frame, because time is important. Cases can't move forward without the medical records in workers' compensation world. So, the 30 days, is that a realistic number? Is it not a realistic number? And how are things prioritized?
So there is no statutory construction for prioritization. So it's going to basically fall on our SOPs with our providers. So if the provider says, I want you to make sure you get all of my patient requests done first, or I want you to make sure you get our continuing care done first so that patients don't suffer in their care, those are going to be handled first. So I'm going to defer to what our SOPs for our individual providers would say. Then with respect to the 30 days should be sufficient. That's what's required under HIPAA for a patient request, not for a third-party request, but for a patient request. And 30 days seems to be consistent across the country. There are some that have lesser standards. I just took a note here that I want to research what we believe our turnaround times are in the state of Connecticut as an average. Now, I will caution you that if I come in with a really low number, it's going to be because we count our turnaround time from when we enter it into our system. And as was pointed out earlier, I believe it was Jennifer who mentioned that there are some delays possibly from when the provider gets it to when it gets into our hands. I think maybe Representative Conley had mentioned something like that too. So we may not, I may come back and tell you like our average turnaround time is 11 days. And you're like, that's impossible. Why do I have all these late requests from PsyOx? Maybe it's because our providers at those sites are taking 2 weeks to get it to us. And we're not aware of that. We don't know when it comes in. We're putting it into our system and measuring our turnaround time. So I do have a note here to see what I can find out about our turnaround times in Connecticut, both for hospitals and for individual providers. I also have a note here that I took that I want to see what data I can find just from a PsyOx perspective, because I'm not going to know industry standard, but I want to know how many non-hospital customers we have. So like practice groups, individual doctors, etc. Now, I don't know how many there are in the state of Connecticut, but maybe if someone can provide that, then I can say we service this many, and then we can figure out the percentage from there. Now, that's not going to include a HEOS numbers, but maybe Liz can commit to trying to find out the same information.
Yep. I'll happily work on that for you.
Thank you. Mike D'Amico?
I just had one quick question, Kyle. If the legal requirement under HIPAA and other statutes is 30 days from the time the request is made to the provider, then is it not tracked in some way when the request was received in order to comply with the 30 days?
In our systems, we put in the date when we receive it. And someone may take fault with our process on that. That's how we're set up. That we put it in on this date, and that's the date. Now, if we receive a subpoena and the subpoena has a due date, we do put in a due date for the subpoena. And there are certain other requests, like we'll have government requests from administrative agencies that are conducting investigations, for like Medicaid fraud, waste, and abuse investigations or things of that nature. And they'll have like, we need an answer by this day. And because that's an administrative agency, we will comply with that. We'll put that in as a due date.
It just seems like to me there's a disconnect, because if the way the law is written, which I believe it is that the 30 days runs from the date of the request, once it's received by the provider. If the provider hangs on to it for 2 weeks, then presumably SciOx would have another 2 weeks and change in order to deliver the record. But it sounds to me like that type of calculation isn't happening. The provider can get a request, transmit it 3 weeks later, and then how is the 30 days tracked? I mean, who's keeping track of the 30 days? I guess is where I'm seeing somewhat of a disconnect that is probably something that we need to get a handle on in order for the time limitation to have any teeth.
I would agree with that. You can understand why on our end we would want to track when we put it into our system, because that tracks our efficiency as well, right? And I will say that I probably should mention this earlier, and it just slipped my mind. But when we respond to a request, if you get a correspondence letter from us saying we need you to complete the authorization, or let's say we need a state documentation, or whatever the excuse is for why we cannot fulfill it at that time, we close that request out at that time. So that is our turnaround time. Even though you didn't get a record, you got a response from us to that request. So that would close our file. And then when you send us the new information, we enter that as a new request at that point, and the clock starts ticking again. So I'm curious if, when we hear that, it took me 45 days to get this record or 60 days to get this record, is it because you're looking at from the time you initially sent the request in, but when we open up a new file because we needed additional documentation on our end, it looks like it was fulfilled in a timely fashion because we got you a response within a timely fashion. We just couldn't get you the record. And then when we finally got the documentation we needed, then we again fulfilled it within a time restraint. Does that make sense?
It does, and we've experienced both. Obviously, when there's additional documentation or incomplete documentation in terms of the request, it's not your fault. I mean, that's something that we have to make sure that we submit the proper documentation that's necessary in order for you to fulfill the request. But oftentimes, it is not a situation where there's inadequate or incomplete documentation. It's simply a timeliness issue. And it sounds, based on our discussion here, that there's, and I'm not criticizing you in any way, but sounds like there's a little bit of loosey-goosey going on between when the request is received by the provider in terms of the time limitation starting to tick, and when it's actually, who's paying attention to that? I mean, it sounds like you're tracking your own efficiency, which is understandable. The provider doesn't seem to be tracking the time limitation. It seems that there should be some communication between the provider and SciOx to make sure that time limitation is met. But it doesn't sound like that process is currently working the way it should. Again, it's not a criticism. To me, it's enlightening and may help explain some of the delays that we're seeing.
Does the providers have any input, or any of the providers on the Zoom keeping track of that number?
So I don't want to speak out of turn, but Kyle can't speak for how the providers track that. And frankly, I suggest he not, because that is tracked. It is part of their compliance requirements. So I will do my best, Representative Connolly, to go back to we have several groups that work on this just generally and try to get you some statistics on how often they believe they're not hitting the 30-day mark. Everyone should also know, because I don't want everyone to be surprised, there's a federal proposed rule pending to move the entire shebang to 15 days. That might change everything, because that'll change the entire structure of how things have to be staffed and how they're going to work. And that's been pending since December 2020. So if that happens, this will change a lot of things, because that's going to be that's just going to change how it has to be staffed and the resources that have to go into it.
Yeah. And Jennifer, as you're following up on that, if there's a data entry on the second request for the situation where it was received by the doctor but not sent to the provider, and a second request went out, if that data point's tracked, could you let us know
Yeah,
date
I
line for
will.
those?
I will definitely look. And so the general answer is going to be when they believe they have the right, I'll call it paperwork, to make a release, which may not be the full release you want. That's when HIPAA would require the 30 days to start. But it's a great question. I will go back and check for metrics.
Thank you.
Thank you. Okay, one general question that I had, I do both personal injury and workers' compensation. On the workers' compensation side of things, most of us use a HIPAA compliant form that is released by the commission. On the personal injury side of things, I think we've all come up with our own medical releases that are HIPAA compliant, but there may be some variations in it. Does SCIOX or any of the other third-party vendors, do you have your own HIPAA form? And what my thought process is here is that if you do, we send in our request on our form initially. Would it make any sense then for you to send your form to us have our clients sign it, and then because it's your form, it's at least going to expedite that part of the process?
If I can answer first, Kyle. I don't necessarily know, Representative Quinn, that the individual company's own forms would expedite the process. One of the things that we really do intensive training on is being able to recognize the elements of a HIPAA compliant authorization so that no matter what format it comes to our member companies, that it's able to be, acted upon quickly and records released if we're able to. I know that we do have, my company, Furismo, we do have an authorization that we'll give to our clients. But generally speaking, we would usually defer to our clients for their authorization. But honestly, we'll take any HIPAA compliant authorization that comes in the door.
Well, right. But what my point is that if it's a format that your company and your company's attorneys have signed off on, and it says medical release, and it says SCIOX compliant or MRO compliant or whoever compliant on the top of it, wouldn't that then take out of the process whatever review that your people would need to do of a medical release sent in to them? If it's one that you already have decided is what you want it to be?
It may cut down on some time, but they're still going to have to go through and validate that it is the correct patient, what is requested, and the authorized, individual signed off on the release. So it could probably help with some of the determining if some of the required elements are there or core statements, but there's a certain amount that they're still just going to have to, unfortunately, validate, themselves.
If I may weigh in, I think that the gist of the question is, would having a form authorization that's required in the state of Connecticut expedite the process a little bit? And I can say that there are states in the country that have actually legislated a form authorization that must be used. And in those states, what it's basically done, it has streamlined it a little bit, but we still make sure that that form complies with what we received. Does that make sense? So we still do look at it to make sure that, yes, this is the one that's required by the law. Like California is one, for instance, where it has the actual authorization in their statute. So I do think it would expedite it. We would just have to streamline our training to say, instead of looking for these elements, look to make sure that it matches. And then once it matches, then you're good to go. And I don't think that the language would be so specific or nuanced that, using an A versus a that's not going to matter. That's not what we're looking for, right? We're looking to make sure that you've got the common elements. Did you give them notice that it could be redisclosed? Did you give them notice that they can terminate the authorization at any point in time just by telling the person? Those things. So I do think that bringing some harmonization to the authorization would expedite it. I don't think that it would reduce it down to where it wouldn't require any labor, if that makes sense.
Okay. All right. Thank you. And for the third-party providers, how do you deal with ongoing disclosure? I mean, when I send a records request into, more often than not, an orthopedic doctor, we always put language in the letter that we want to see it. Please consider this to be an ongoing request and continue to send us the records. And probably more often than not, that doesn't happen. Is there anything that we should be doing to make sure that ongoing disclosure does happen, or what problems does it cause either the doctor's office or the third-party medical records? Because in our minds, that should make the process go quicker if I don't have to have my paralegal, send out another request every time our client lets us know that they've been to the doctor.
Yeah, unfortunately, with the number of requests that we get on a regular basis, we don't have a way of notifying in the file that whenever patient John Doe has another visit to the doctor, that record should be sent to the certain requesters. So that's why there's a problem there, and why you're not getting those updated records is because we rely on when we get a request. That now, if we could streamline the process to make follow-up requests easier, I'm all in favor of that. And then that way we're not producing any and all, we're only producing from a certain date forward. But we have not come up with a way to monitor, did John Doe come in today? Did he come in tomorrow, the following day? Because that's really what you're asking for, is whenever that patient then comes in, if you've received one authorization, every time that patient comes in to treat, send me his record. And we haven't devised a way to do that yet.
Well, and again, this gets into software capabilities and things that are beyond my knowledge, but my client is seeing Dr. X. We send in an initial records request as an ongoing request. Systemically, couldn't it be put into the patient's record that every time you receive another record from Dr. X, that it is just automatically sent out without the necessity of a request, I guess is the question that I would have.
And I think the problem there is what we've identified with getting timely requests to the third-party vendors is we're not going to know that patient treated. So it would be incumbent upon the provider who knows that John Doe came in to tell us, hey, this patient came in again, you already had a request, so go ahead and send this out too. Because we're not just going into the record to see who had appointments that day. We're only going into the record when we have authorization to do so, which is by the form of a request. Does that make sense? So we don't have the ability to put a tickler on the file to say, hey, John Doe's record was updated because of a visit, so we need to go and pull that record. We only go into the record when we've been requested to by a legal request. So again, that would take a communication between the provider who does know when John Doe came in and their vendor, like a SciOx or MRO, et cetera.
Well, I would assume then that regardless of whether it's a litigation file or not, if you're handling medical records for a particular provider, and the provider is sending them to you, you would be putting them into the person's electronic file, and can it just be set up to just automatically send it out? I'm not putting any burden on you to actually look at it or track it down or anything. But if the doctor's sending their records to you and it's getting put into the electronic file, can't that file just be marked that every time a new record comes in, and not you having to look for the record or track the record down, but you get it in, you send it out to the lawyer because the client has agreed to ongoing disclosure?
I think that's part of the problem, is that the provider doesn't send us records. the provider gives us access to their EHR. So SciOx doesn't assume the responsibility for uploading any records into the EHR. The provider has either they do that themselves or they have another vendor that may upload paper. And then when we get a request, we access their EHR. So they don't send us like, if we get a request for John Doe's record, we don't say to the provider, hey, can you send us John Doe's records? We have access to it. We have credentials to sign into the EHR and pull it directly ourselves. So the provider, to take that to the next step, when John Doe comes in for a follow-up treatment, they don't send us John Doe's record and say, hey, we have a new visit date. We would have to go in and find out that he had a new visit date by going into the EHR. Does that make sense?
Yeah, it does. It does. Okay. Does anyone else have any questions or comments on anything today, or topics that we didn't get into today that you would like to see us get into on the next meeting? Okay. Then before
Real
I
quick,
go ahead.
We did need to vote on the minutes earlier in the day.
Yeah, I noticed that as well. So we did have a motion and a second on the approval of the minutes from October 24th. Were there any comments, questions, corrections on the minutes? Seeing none, we'll proceed to vote. All those in favor of accepting the October 24th minutes signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. All right, our next meeting will be Tuesday, November 28th at 10 in the morning, again, virtual. And if there's nothing, go ahead, Rick.
You're muted.
Are we going to have, I'm sorry that I missed the first meeting, but are we at some time going to consider a proposal by statute to make some changes in the current legislation?
Yes, that's the ultimate goal, and to come up with some sort of consensus with the group as to what that would be, with the thought being that if we have, I'm not thinking we'll have unanimous agreement, but if we can come up with something that everybody can live with, that'll just make the legislative process that much simpler come February. So yes, that is the ultimate goal, is to have legislative proposals that we would then forward on and hopefully be considered and acted upon during the session that starts in February.
Are we going to have proposals by draft? In other words, each of the party may submit a draft proposal that they think is fair and adequate?
Yes. And I think that there'll probably be points in everyone's proposals where there's agreement and points where there isn't, and it's just coming up with a consensus on the areas where there's disagreement. Any other questions or comments?
Yeah, one of the things that we didn't discuss, and it's not my expertise, but I thought there was an issue that hadn't been discussed with workman's compensation as to what the cost of one page would be. I had understood that was an issue, whether there should be any cost or not.
Currently, there isn't any cost. You know, all the costs are associated with personal injury cases.
That's what my understanding was.
Okay.
I think the issue that Rick may be referring to, and you correct me if I'm wrong, Rick, it was something that I had mentioned, perhaps not as clearly as I should have earlier, and that is when you have recurring visits with a single provider and you're only requesting what turns out to be 1 or 2 pages. I know that in other legislative proposals that have gone on around the country, there has been some type of set fee for each request, be it $25 or something of this nature. And when that request entails only a page or 2 pages of records, I know that there's been voiced concern about whether or not such a cost would be deemed to be reasonable, even under the federal law for that matter. But
That was not workman's comp. That was liability.
yes, that's true. Not comp.
All right, then. We will see you all back here on November 28th at 10 o'clock. And if I could just have a motion to adjourn.
Motion to adjourn.
Second. All in favor?
Aye.
Okay. Thank you all very much, and we'll see you on November 28th.
Thank you.
Stay
All right,
well.
thank you.